It's live. Good
Hello,
work.
hello, everybody. Our this breakout session will begin in just a moment. Just want to give everybody an opportunity, 30 seconds or so, to get in and to join, and then we'll get started. So just sit tight for a couple of seconds here. Okay, I hope that was enough time just to get everybody settled. Welcome, everybody. I am Lori Escobar. I'm the Director of Operations for the Alzheimer's Association New Mexico chapter. I hope you've been finding some great useful information today. I know this presentation you will find very useful. This is the use of trusts in Medicaid and VA planning, and I'm very pleased to introduce and turn it over to Lori Millet of Albuquerque Elder Law, PC. Lori?
Good afternoon, everybody. First of all, let me say I'd much rather be doing this in person. I'm so sad that I'm not getting to see everyone and interact with everyone on a personal level, but you know, the virus is what it is and we have to adjust. I don't like change. I don't know about you, but I'm trying to go with the flow. So this topic is actually pretty complicated. I have a lot of information to share with you, and I am sure that it will be useful to you if you do have any need to plan for benefits, whether they're from Medicaid or the VA. So let's go ahead and dive right in. The first thing I want to do is recap what the eligibility rules are for Medicaid and for the VA. Now, there are two benefits that are commonly mixed up at the VA. I'm going to be focusing on the benefit that's commonly called aid in attendance today. And then I'm just going to explain really quickly what the difference is between that and service connected disability, which results in a benefit called compensation, which is completely different. So for Medicaid, there is a medical eligibility and then there's financial eligibility. And the financial eligibility is bifurcated into two parts. The first part is income, and the second part is resources. So a Medicaid applicant is not allowed to have more than $2,349 in income for 2020. I am confident that's going to change in 2021 because Social Security has announced a 1.3% increase for the cost of living adjustment, which is commonly referred to as COLA. For resources, you're not supposed to have more than $2,000 in the bank or $2,000 total in bank and other resources. And then for married people, the well spouse, which is also called the community spouse, is allowed to keep half of the total assets up to $128,640. And there is some significant planning that can be done to try and preserve other assets for that community spouse, which is a little beyond the scope of what we're doing today. But I wanted to let you know that that is not a hard and fast number. Medicaid has a 5-year look back. So when you apply for Medicaid, if they see anything suspicious or they just want to know more about how you've been spending your money, they have the right to come back and ask for 5 years worth of financial statements. If they find things they don't like, they are going to, in other words, transfers or gifts, they are going to add all those up and impose a penalty period. So that's why no transfers is my mantra for all of my clients who come in to do Medicaid planning. The house is an exempt resource. Medicaid will not take your house as long as you say you intend to return home. And please note, that is not a realistic intent. It is a subjective intent. In other words, you know that there's no way your mom or dad are ever going to be able to go home, sadly. But as long as they say they intend to return home on the Medicaid application, the house will be an exempt resource. Now let's contrast all this with aid and attendance. Aid and attendance financial qualification is quite different. Instead of using an income cap, the VA goes by unreimbursed medical expenses, which they refer to as UMEs. The UMEs have to exceed the monthly income of the claimant. The claimant is always the term used for the person who is applying for VA benefits, whether it's the veteran himself or herself or the surviving spouse. Even single people are allowed to have $129,094 in resources for VA purposes. And I think that's going to go up next year because of the COLA increase as well. Instead of a 5-year look back, the VA has a 3-year look back. And medical eligibility is assumed if you have enough UMEs. And just like Medicaid, the VA says your house is an exempt resource, although it has a few more little persnickety rules, but again, that's beyond the scope of what we're talking about today. There are so many different kinds of trusts. There are revocable trusts, irrevocable trusts. We're going to talk about an income diversion trust. But I want to tell you what kind of trusts do not work for eligibility for either of these programs. Living trusts, which are the most common kind of revocable trusts and what people usually think of when they hear the word trust. These kinds of trusts almost always name the Medicaid applicant or the VA claimant as a beneficiary. And that means that all of the trust principal or corpus, in other words, everything that's in that trust pot, is included as a resource. Or these kind of revocable trusts give some kind of control to the grantor, who's the person that set up the trust, so that the grantor is deemed to have control over those assets, which makes the assets countable. For VA benefits, even special needs trusts are countable resources. And that's really important for you to know. So I'm going to say it again. For VA benefits, even special needs trusts are countable resources. And I'm going to go over the different kinds of special needs trusts that there are in a little bit. Irrevocable trusts are typically what are used for Medicaid and VA planning, but irrevocable trusts that provide income to the grantor are going to cause some problems. They are going to likely cause the entire trust corpus or pot to be included as a countable resource. The income, if it's distributed to the grantor, is going to affect the UMEs for VA benefits. Because remember, the UMEs are unreimbursed medical expenses. And if you are getting income from an irrevocable trust, then the VA is going to presume you need to use that money to pay those medical expenses first. So you're not going to be as much in the red as you would otherwise be. They also could put the Medicaid applicant over the income cap, because remember, the income cap is $2,349. And if you've got other income coming in on top of that, you're going to need an income diversion trust. So my opinion is irrevocable trusts that provide income to the grantor are too risky and you need to avoid them. Trusts that do work, income diversion trusts, which are only used in Medicaid planning, irrevocable trusts that are drafted correctly, in my opinion, that do not give income to the grantor, and special needs trusts, but those only work for Medicaid. Now, service-connected disability. This is the other kind of VA benefit that you need to consider if it is available to your loved one. Service-connected disability results in what are called compensation payments to that veteran or the surviving spouse in some circumstances. This is not a needs-based benefit, so no financial planning is involved. It is like an entitlement from the VA, like Medicare is an entitlement for people who are 65 and older. Now, disability ratings are given in 10% increments, and the VA does some funny math. 1 + 1 does not equal 2. Sometimes it equals 3, or sometimes it equals 1. And I cannot even give you a formula for how they do that, but it's important that you know if you have a 70% service-connected disability, then the VA will pay for nursing home care for that applicant. And so sometimes the best thing you can do is to see about getting that disability rating increased so that you can get a 70% or higher disability rating and maximize the benefits from the VA without having to go through all of that financial planning that you would need to do for Medicaid and aid and attendance. Now keep in mind, if you do ask for an increase in your disability, in the disability rating, then the VA may conclude that the disability has gotten better and lower the disability rating, so it could backfire on you. So be pretty sure that the veteran is entitled to an increase, not a decrease. And this is the last point I want to make about service-connected disability is that you cannot have compensation and aid and attendance. That is forbidden. The compensation for 100% is far higher than the maximum you can get for aid and attendance. $3,200 for compensation, actually it's closer to $3,300 versus $2,200-ish for aid and attendance. And the VA will award the higher of the two benefits. But as you can see, $3,200 a month, both are non-taxable income, but the $3,200 a month is a lot better benefit than $2,200 a month. Not $2,200 a month is for a veteran and his or her spouse. Income diversion trusts. These are the most common types of trusts for Medicaid planning. You use these when the applicant's income is over the income cap. As I mentioned earlier, the amount of the income cap changes every year if there is a COLA adjustment. So the way they work is all of the applicant's income goes into this income diversion trust pot, and then $1 less than the income cap comes out, and that is what is used to calculate the personal needs allowance, the trustee fee, and the patient pay liability, which I'm going to get into in detail in a few minutes. I even drew you a very nice diagram. So what happens to this accrued money? Well, it stays in the income diversion trust account, that excess, and you can never, ever, ever touch that money for any reason, not for taxes, not for medical care, nothing. Because if you do, you are opening yourself up for criminal prosecution by the state. And then when the Medicaid recipient dies, all of that accrued money is paid to the state. So what do all these terms mean? Grantor/settlor is the person who is establishing the trust. Frequently, the person who's establishing the trust or signing it is the power of attorney for that Medicaid applicant who I'm going to refer to as the beneficiary for the purpose of discussing income diversion trusts. Beneficiary is the person who needs Medicaid. And sometimes these trusts call that person the lifetime beneficiary. The trustee is the person who controls the money in that income diversion trust pot. The personal needs allowance is the amount of money that the beneficiary is allowed to have every month from that $2,348. For 2020, that amount is $76. And Medicaid considers that entire $76 to be fully spent every month. The trustee fee is what the trustee is entitled to get for the trouble of administering the income diversion trust. And for this year, it is $70.44. And then the patient pay amount is like a copay that goes to the facility. Now, how do they work? The pink circle is the income diversion trust. So let's say that your loved one has two sources of income. Let's say it's Social Security and a pension. One is $1,500 and the other one is $2,000. So $3,500 is clearly above the income cap of $2,349. $1 less than the income cap comes out every month. So from that $2,348, the trustee is paid $70.44, and $76 is allocated toward the personal needs allowance. The leftover $2,201 is the patient pay amount or the copay to the facility. This 1152 figure that's in blue is the excess or the difference between the 2348 and the 3500, which is the total of the two sources of income. That 1152 stays in the pink trust pot every month. And when the Medicaid recipient passes away, a check is written to the state for all of that accrued money. So let's look at these numbers in detail. Social Security is $1,500, pensions $2,000, so the total income is $3,500. So Herb, our fictitious Medicaid applicant, has more than $2,349 of income, so he won't qualify, right? So we do an income diversion trust for Herb, and then he has $1,152 left over that has to stay in that income diversion trust. So Herb qualifies now, but the 1152 has to accumulate in that trust every month. The accumulated money is tracked by Medicaid. Every year you are on Medicaid, you have to go through a process called recertification, where you show Medicaid that you are still entitled to receive the Medicaid benefits. Each year during that recertification process, the caseworker is likely to tell you how much needs to be in that income diversion trust account and want to see an actual bank statement. And that audit can be really helpful so that you're aware of any discrepancies, because unfortunately discrepancies do happen. The most common discrepancy that I see is that Medicaid doesn't tell the trustee that there has been an increase in the income cap, which translates to an increase in the amount that must be accumulated. So, for example, if we go back to our 1152 example, this 1152 would actually be different if this amount changes, the 2348, because of a COLA adjustment. So you want to make sure that you stay on top of that And although Medicaid used to tell you that things have changed, they don't always do that. So the trustee needs to take responsibility for keeping up with what those figures are for the current year. All right, special needs trusts. There are 3 basic kinds: payback trusts, third-party trusts, and pooled trusts. Payback trusts are also commonly referred to as first-party trusts or D4A trusts, and that nickname comes from the actual statute under federal law that establishes the ability to have a payback special needs trust. And what that means is the payback comes into play when the Medicaid recipient dies. Medicaid has the first bite at the apple of whatever remains in that special needs trust. If there's anything left after Medicaid is paid back, then the trust has rules that say who gets the leftovers. And those are called remainder beneficiaries. Pooled trusts, you're probably not going to see these too often, but you might. They are also sometimes referred to as D4C trusts because it's another kind of trust under that same federal statute. The trustee of these trusts must be a nonprofit by law. And there's a payback provision, but instead of the trust having rules that says who gets the leftovers after Medicaid is paid back, the leftovers are reallocated among the other pooled trust beneficiaries. Third-party trusts are trusts that typically parents set up for a disabled child, and there is no payback to Medicaid because it isn't the Medicaid beneficiary's money that funds it. For the pooled trust and the payback trust, the money that goes into those trusts belongs to the Medicaid beneficiary, such as from an inheritance or being mistakenly named as a beneficiary of a retirement account. Please note that for all 3 of these kinds of trusts, the Medicaid beneficiary must be less than 65 years old when the trust is established. They can have the trust when they're 70, provided it was established before they turn 65. Payback special needs trusts are very common for personal injury settlements, and there are restrictions on distributions. You cannot make distributions from the trust for food or shelter. And I just threw in here a little snippet about an ABLE account, and I'm not going to go into that in a lot of detail, but if you have questions about ABLE accounts, please feel free to contact me. So the trustee has to be very mindful of the distributions that are made. Nothing for rent, nothing for a mortgage payment, no property taxes, but examples of allowable distributions are for a computer, a phone, or some kind of travel. The payback special needs trusts have that payback provision to the Human Services Department or Medicaid, only to the extent that Medicaid has paid benefits out. And the trust must say that if the beneficiary has lived in more than one state, then each state gets a prorated share of what is in that trust. Pooled special needs trusts are good for very small amounts of funds, and ARC and ARCA are the 2 big typical trustees. The remaining funds get allocated to the other beneficiaries after the payback. And one of the biggest benefits of having a pooled trust is that the trustee the family member who would otherwise be serving as a trustee in a regular payback trust is not put in the position of saying no to the family member who may want a new car or want some other item that the trustee does not feel is appropriate. And The family member does not have to keep track of those tricky distribution rules. Third-party special needs trusts are frequently used to plan for disabled children. The grantor says who gets any leftovers that may be there, but the same restrictions on distributions apply, the only difference being Medicaid doesn't get any of the leftovers. Now, testamentary supplemental needs trusts, sometimes they're referred to as testamentary special needs trusts, are a very important tool in planning for elderly folks who are married. Testamentary means set up in a will. This is the only exception to that you have to be under 65 rule in order to have a supplemental or special needs trust. It must be set up in the will of the deceased spouse, not a trust. Has to be a will, not a trust. So how do these work? It's easier to just give you an example. Jack and Joan are married. Jack is diagnosed with Alzheimer's disease. He has to go into a facility, and because Joan just can't take care of him anymore, and they don't have the funds to pay for that facility. Joan goes to see a Medicaid attorney, and she does perfect Medicaid planning, and Jack is in a memory care facility where he does really well. Unfortunately, Joan dies unexpectedly. We don't want Jack to inherit from her, because if Jack inherits from Joan, he's going to lose his Medicaid. And it was difficult for Joan to get him on Medicaid in the first place. Hopefully, Joan went to a lawyer who advised her to do a will that had a provision in it for a testamentary supplemental needs trust, so that any inheritance Jack would otherwise receive from Joan is funneled into this testamentary supplemental needs trust, and Jack doesn't lose his Medicaid. He gets to stay right where he is, so there's no change to get him all confused and possibly cause his dementia to get worse, and he gets to stay with the same care team. And that's really important because he doesn't want to have a bunch of strange new people around him every day. That's just going to throw him off. Irrevocable trusts. These are really complicated, and it is largely due to tax considerations. If they're drafted well enough, you can have some very good tax benefits, but you've got to be able to get the grantor through the look back period, whether it's VA or it is Medicaid. The concept of how they work is that you transfer enough of your excess assets to the irrevocable trust, and then you leave enough assets out of the trust to get you through that look back period. And if you recall, for aid and attendance, it's a 3-year look back, and for Medicaid, it's a 5-year look back. Careful calculations have to be done in order to make sure that these trusts work the way they're supposed to, but the wild card in the whole plan is what the grantor's level of care is. And nobody can predict that. So if John is doing pretty well, he's stable, you don't think he's going to need Medicaid for 5 years, but then he has a stroke at year 3, maybe he didn't keep enough money outside of the trust to get him through the remaining look back period, and you've got yourself in a bind. So they're risky. Translation, the sooner you get them done, the better off you are. But the drawback is you don't have any control. The grantor doesn't have any control over that money. And that's why people do not like to do them when they're young, which is the ideal time to do it. Not young, like not in your 40s or 50s, but probably in your 60s, maybe early 70s. Or if you come down with a diagnosis of Alzheimer's in your 60s, but it's not early onset, that's going to have the very quick progression. So it all depends on the level of care and the diagnosis and some other medical conditions that the grantor may have that are going to affect possibly how the dementia progresses. The applicant or claimant, remember applicants for Medicaid, claimant is for VA, is the grantor, and the distributions are made to the lifetime beneficiaries, which are typically children. And hopefully they're good children. You cannot have, in my opinion, it's way too risky to have those trust distributions go to the grantor because it's going to affect VA and Medicaid, as I described earlier. And the part that people really don't like about these trusts, in addition to losing control over the assets that are put into the trust, is that the distributions are considered taxable income to the lifetime beneficiaries. And for a child that's already in a pretty high tax bracket, those distributions may push them up into the next tax bracket and increase their income tax liability. The trustee of the irrevocable trust can make additional distributions to pay the additional taxes, but then they're moving up again into possibly into the next tax bracket. It just all depends on how the numbers work out. So I always advise my clients to have whoever the lifetime beneficiaries are going to be, doesn't have to be children, to go and sit down and have a long talk with their accountants to make sure that the right kind of planning is done so that they do not have overly adverse income tax consequences from having these trust distributions given to them. So let's look at why you might do an irrevocable trust versus gifting. Because hopefully you can't give money away and still qualify for Medicaid. That's another myth. It's okay if I give my money away to qualify for Medicaid. I'll get down to $2,000 or less and everything will be hunky-dory. No, everything will not be hunky-dory. Medicaid's going to impose a penalty period on you if you have to apply for Medicaid within 5 years that you made that gift. So if you make the gift, you've got to get through the look-back period. But for the irrevocable trust, you have to get through the look-back period as well. The biggest risk in plain old gifting is that the gifted funds are subject to the child's or the donee's creditors. So let's say you give money to your son and your son is married and then he gets a divorce. That money is considered his money, even though you gave it to him. The divorce lawyer for his wife says, oh no, that's your money, and it's subject to division between son and soon-to-be ex-daughter-in-law. It doesn't matter where the money came from, because once the gift is made to son, the law says that money is his. And that applies to judgment creditors, bankruptcies, and so forth. And the other risk is the child does not have to use the funds for the parent's benefit, because that's usually the theory. The gifted money is going to be used by the child to pay for whatever the grantor needs, particularly through the look-back period. So let's contrast this with an irrevocable trust. Because it's an irrevocable trust, the trust assets are protected from the child's creditors. In other words, divorce lawyer can't get to that money because it isn't the child's money. So it is not subject to division in a divorce settlement or in a bankruptcy court or in some kind of a judgment situation. But we have the same problem with the child not necessarily wanting to use those lifetime distributions to pay for the parent's benefit. Because the thought is, if the parent runs short during the look back period, child can use some of the money that he or she would otherwise use to pay maybe the mortgage payment, set his own money aside, use the trust distributions to pay the mortgage payment, and let that income that is his own income from his job accumulate in a savings account in his name. And then if mom or dad needed something, he could make a gift to them. Child making a gift to parents is fine. Parents making a gift to child, not fine. And that is how these kinds of trusts work. And I think I have left enough time for questions.
Yes, Lori, you have. That was an amazing presentation. And I will ask anybody listening in here, if you have questions for Lori, go ahead and type those in to the chat box right now. I currently don't have anything, Lori, but it certainly also sounds like there's so many aspects to this that having a really good elder law attorney is especially important to help a family figure this out and get things set up right. And it can also be, take some time for this to happen as well.
That is correct. Yes, that's right. I mean, because these irrevocable trusts in particular are so complicated, it takes a while for the kids to go see their accountants and then analyze their personal financial situation. It takes a while to get the trusts themselves drafted up. And so irrevocable trusts are not good for crisis planning at all. Neither is gifting. Don't gift. That's my mantra. Just say no to gifting.
And so you touched on the term crisis planning, meaning that, a lot of this should be considered well in advance, or even at a very early diagnosis, say, of a form of dementia. This type of legal planning is really crucial in the beginning, rather than waiting to a point where it does become a crisis.
That is absolutely correct. Because you don't know exactly how quickly that dementia is going to progress. And I always see at least several times a month where I have someone come in, they want not only the spouse, let's say, to sign powers of attorney, but they've waited too long. And the spouse can't sign powers of attorney because they don't have the legal capacity anymore. And if they can't sign powers of attorney, they can't sign a trust. So a power of attorney can give the ability to sign a trust on the dementia patient's behalf, but it's got to be drafted right. So well-drafted powers of attorney are really, really important too.
And then one last question I would have, Lori, is do you feel, obviously, since you are a designated elder law attorney, that utilizing an elder law attorney who specializes in elder law may be more advantageous than just somebody who is not as specialized?
Oh, absolutely. And I'm just not trying to toot my own horn at all. Regular estate planning attorneys typically do not understand Medicaid. Some of them don't even understand that you have to have, or you should have, a testamentary supplemental needs trust for your spouse in a will. And then by the time the well spouse comes to me, I can't help them the way I would have been able to if everything had been done right in the beginning. And that's not a slur on regular estate planning attorneys at all. They're specialists in probably tax planning, not planning for long-term care benefits, because it's really hard to know how to do both. It takes a lot of time to keep up with the constantly changing regulations for Medicaid and the VA. And then it's also hard to keep up with the big changes in federal law that affect regular old estate planning, like we had the Secure Act this year. That hasn't been a topic in this conference, But the Secure Act really changed how retirement accounts get distributed out after the retirement plan participant passes away. And so those are the kinds of things that regular estate planning attorneys are trying to focus on, whereas you have someone like me who's trying to keep up with all of it, and it's just difficult. It takes a lot of time. So you want to make sure that you're talking to someone who understands a little bit about VA, maybe, in case that's an option, but definitely a lot about Medicaid as well as estate planning.
Great. I don't actually see any other questions in the chat box at this time, other than there was a question as to whether your slides will be shared.
Yeah, you could, sure, that's fine.
Awesome.
I know you have them, Lori, because I sent them to Denise.
Great.
last
Okay,
week.
so for those of you who are listening in, I will put in the email, I'm sorry, in the chat here, the email address for Chris Chaffin. He's our communications director, and you can email him, and he can get you a copy of these slides. So that is now in the chat. And Janine, to answer your question, oh, there you see it. Okay, yep, just email Chris Chaffin and he can get you a copy of the slides. Any other questions at this time for Lori?
I'm ready, guys. Come on.
Yeah, well, we have her. We've got plenty of time. Deborah, you've raised your hand, I see, in the Zoom, but unfortunately you'll be muted. Do you have the ability to type something into the chat box? Yes, she is typing. Let's see if something comes in.
Okay, now that I said I was ready, I hope I can answer Deborah's question.
Looks like she may still be typing. Okay. She says, great presentation. And is it the only over 65 option is the irrevocable trust?
No. Oh, well, if you're single, yes. If you're married, you can have a testamentary supplemental needs trust in each other's wills. So, for example, let's go back to my Jack and Joan. Are my slides still showing, Lori?
Yes, they are.
Okay, so let's go back to my Jack and Joan example. Let's say that Jack is 75. So he's over that 65-year limit. But if Joan leaves her will, puts in her will the provision that the personal representative can do a testamentary supplemental needs trust for Jack, then Jack won't lose his Medicaid even though he's over 65. If Jack is single, then Jack could do an irrevocable trust, but he's got to have enough funds and enough calculations have to be done to get him through the look back period for whichever benefit he's seeking to get.
Okay, and then we have another question that's come in. If a trust is established in New Mexico and we move out of state, what then?
Okay, so that is a really good question. The general rule is if a trust was validly executed in one state, it should be recognized in the next state. Now that is subject to some really technical rules about trust administration. But for the irrevocable trust, as long as they're done right in New Mexico, they're probably going to be accepted in another state. Now for special needs trusts, there could be something that has to be changed because Medicaid law is different in every state. And good special needs trusts are drafted to allow the trustee to make changes for that purpose only. So even though special needs trusts are irrevocable, they almost always have a provision that says, if there's a law change, the trustee can make the change to the trust to comply with the law.
Great. We have another question here. Why does the VA not recognize widows of vets for aid and attendance if the spouse served 4 years, but it was not during a wartime?
That is the rule. The veteran had to have served 90 days during a period of war. They did not have to be boots on the ground. They didn't have to be in the midst of the fighting. They just had to serve during that declared period of war. And there's quite a long list of wartime periods that have been set by Congress. The most common exception not exception, the most common problem that I see is our veterans who have served between Vietnam and Korea. I get quite a few of those each year, and unfortunately, there is nothing you can do. And I also want to mention that for National Guard duty, you have to be activated by the feds, not the state, in order to be considered eligible for aid and attendance.
Okay. Let's see, it looks like that is all the questions I have. I'm going to make one more call for questions that you can type into the chat box. Here's one more. Does the VA require the diagnosis to be by a VA doctor?
No, it does not. There are pros and cons to having a VA doctor fill out the doctor's affidavit, because then the doctor has access to all of the wartime medical records, and so he can go back and make that connection between what's going on with the veteran now and what may have been causing the disability, which is really important for service-connected compensation or disability claims. But the VA will accept a non-VA doctor filling out the physician's affidavit for aid and attendance.
Okay, great. All right, last call. Oops, we've got another one. Is it possible that the VA could change the rules in the future about serving during wartime?
I don't see that happening. I just don't. So I have my little list here. We have been considered to be in a wartime period since August 2nd, 1990. And the only thing that's going to change, or the only thing that I think is possible to change, is that wartime period right there. I don't think the VA is going to go back and ask Congress, because it's Congress who set those rules, not the VA. I don't think the VA is going to ask Congress to include any other non-periods of war to allow more veterans to get benefits, because they're already short of money.
Great. Okay, we have some comments. Thanking you, Lori, for the great presentation.
You are very welcome.
And one more here. What questions should we be asking that we haven't? Do you have anything to add?
That is a loaded question.
Right?
I really tried to anticipate all of the questions that you would be asking me and address them in my slides. But if you think that your loved one is going to need Medicaid or VA and some kind of trust planning or financial planning is going to be necessary, please go see someone to get that planning in place sooner rather than later. Do not procrastinate. That will bite you if you procrastinate.
And again, this is more about long-term care planning than estate or tax planning. Big difference
That is correct. That is correct. Because the people who need this kind of long-term care benefit usually do not have long-term care insurance, which in my opinion is worth its weight in gold. But it is expensive, and people feel that they have not been able to afford it. And so now they're having to look at planning for public benefits.
Okay. Well, Lori, I want to thank you, and I want to thank everyone who's on this breakout here. I think this is very valuable information. And as Lori said, if you have more questions, please reach out to an elder law attorney. And just a reminder, this session was recorded. We'll be sending out emails early in the week to let you know how you can access those. So with that, we're going to end this meeting and we're going to thank Lori. Thank you so much, Lori.
All right, thank you. Everybody have a good rest of the weekend.
Bye-bye.